Welcome to the dissection. Today we are going to be looking at the questions that the justices asked the IEC to just get a feel of where they are.
Yeah, I mean, looking at these types of questions can be quite useful because they can give you a feel for the reservations that judges may have. They can give you a feel for the thought process that judges are going through, and they may even give you an indication of the prospects of success for particular litigants in a particular court. So we're going to focus on the IEC in this particular episode. We're going to do another one where we look at the questions that were asked to counsel for Ngcukaitobis and Jacob Zuma to also see what concerns and thoughts the justices had in that respect. But we're going to start with the IEC because this is their matter. They're bringing it to the Constitutional Court. So let's see what happened and how it played out. And we're going to give commentary as we go and also some reflections at the end.
Especially on the issue of the proviso.
Yes, the appeal proviso.
Yeah. Correct me if I'm wrong, that the section talks about two aspects which you've identified.
Yes.
The procedural as well as the substantive.
Yes.
The substantive being the disqualification and stuff like that.
Yes.
And the proviso being what happened.
Yes.
Yeah. Can it be said that it was the intention of the legislature that I don't want to say an accused person, it sounds too strong a word, a person who is sentenced to 12 months imprisonment would lose all his or her rights in terms of the proviso, number one. Number two, was it envisaged or contemplated that the Constitutional Court would sit as a court of first and last instance? Three, where it has said as a court of first and last instance, what happens to the rights of an accused person vis-a-vis his right to appeal? You have submitted that, and correctly so, that if a person had been sentenced in the magistrate court, he would have the right of appeal, stuff like that. And that sentence in the magistrate court will be given legitimacy and validity. But you said it is absurd of the electoral court to say the sentence in this court should not have the same force of law.
Yes, I'm happy to answer those.
Okay.
Thank you for the questions, Justice Matopo. Let me start with the second question. Was it contemplated that this court would sit as a court of first and last instance? The answer to that is yes, because the Constitution itself contemplates that a direct access application can be brought. And the case against Mr. Zuma was a direct access application. And there was no distinction that you can only bring a direct access application if there will be no punitive order granted. So the answer is yes, it was always contemplated that this court would sit as a court of first and last instance.
You would not mind if I interject and ask questions,
no.
especially on that one. If there is a direct access application in situations of this nature, can it, again, I go back to the intention of the legislature, can it be said that because it's a direct access application, the legislature intended that Mr. Zuma's rights to appeal, if not satisfied, would be taken away from him?
Yes, that's precisely the debate that was held in the rescission case, this entire discussion. And it's fully contained in the judgment of Justice Thembeka, that if the court is sitting as a court of first and last instance, there is no appeal. The reason Mr. Zuma sought rescission was because he said that he has no rights of appeal. Then the issue was debated. And then this court found by a strong majority that that's the consequence of the decision that he made to defy the order of the Constitutional Court. So his rights to appeal were not denied. It was the interpretation of the Constitution that came into operation.
Sorry for the dialogue, it may be necessary just to clarify what I have in mind.
Indeed.
So if direct access takes away his rights of appeal,
No, he has no right of appeal in a direct of access case.
Against, right? But the section speaks about his rights of appeal. I have, or we would have, two contradicting, if I were to put it that way, provisions. One, it's a direct appeal, or direct access, so to speak, which this court regulates its own powers. And now we have the direct access, the section 47, which seeks to exclude him, exclude him. Let me stop there.
Yes, let me answer
just if you can harmonize the two.
Yes,
if they need to be harmonized at all.
They don't need to be harmonized, but let me take the question seriously. This is a proviso. So, by definition, a proviso does not detract from the controlling provision. It's subsidiary to the controlling provision. That's the first thing. The second is that it is a deeming provision. In other words, what it does is that it creates a fiction. See? Because what it says is that no one may be regarded as having been sentenced until an appeal. We know as a fact that you have been sentenced. We know as a matter of law you've been sentenced. But what the law does is then it creates this legal fiction that we will act as if you have not been sentenced. And it is not a section that confers a right of appeal. What it does, it creates the duration, a suspension of the operation of the disqualification until the right of appeal, which is not in the section, until the right of appeal is explored. So if you want to know where is the right of appeal, it's in section 35. This section does not give anyone any right of appeal. What it does is to suspend the execution of the sentence for purposes of section 47(1)(e) until the appeal process has lapsed or has been exhausted. So it's a fallacy, and it's a fallacy that runs through the judgment of the Electoral Court to say there is a clash of rights. There is a right conferred by section 47 and which clashes with the right conferred by section 19. There is no such.
Let me take it a step further. In the event somebody were to disobey this court, I mean the Constitutional Court, and that person's conduct were to amount to contempt, right? Would it be within the remit of this court to deal with him as it has dealt with Mr. Zuma, or would it fall within the remit of this court to convict the person because he would have disobeyed the Constitutional Court? Say, for example, something were to happen now. Yes. Somebody were to be disruptive, and that person disobey the sitting of this court, and then we would have to convict him.
Yes.
And then what do? Do we send him down or we sentence him?
No, you are entitled to sentence him. But once you have sentenced him, it becomes a final sentence. It can be executed immediately. It's no longer suspended by the suspension in 47(1)(e), because that suspension is to hold off the execution for an appeal. But you are a final court of appeal, so your sentence becomes operative immediately.
Perhaps it's a bad example. I think it's a bad example.
All right, let's see if we cannot get a better one.
Yeah. No, I will revert. Let my colleagues. Yeah, I will revert. I think it's a bad example.
All right, thank you, Justice Mutopo.
So I actually don't think it's a bad example.
Why?
I think it's a good example because it shows the complication that has been created by this case. Because in normal instances, you have this right to appeal. So what Advocate Ngcukaitobi is saying is, Uti, there's a special situation where you have no right to appeal. And I don't think that is something that I'm comfortable with, and I don't think that's something that is actually envisioned. That if you get to Concord first, as a court of first instance, then you can forget about other rights that are afforded in the Constitution. And it's a discomfort. And it stems from the original decision to take this issue straight to the Constitution by the Commission, by Zondo, take it to his peers, who he was coming in to supervise later, and he thought So this is all as a result of that original decision.
Just out of interest, Jamie, could he have taken it to another court?
Yeah, he could have taken it to the High Court. He didn't have to take it to the Constitutional Court. But this is the source of discomfort for me, because Advocate Thembeka Ngcukaitobi is being flippant and dismissive. He's just saying, yeah, sure, no problem. You misbehaved in the court, straight to jail. But the Constitution is very clear that nobody should go straight to jail. You should have that right to appeal. It's not a small thing. And Section 47(1)(e) is saying even when you are trying to get into Parliament, if you have not yet exhausted your legal remedies, we will suspend your exclusion, because it is recognizing that right to appeal. So I don't think it's a small issue, and I don't think it's a trivial issue. But I think that it's one which will be asked. And by the way, you learn a lot about the mood of the court. So you could see, for instance, in the recusal section of this particular day, that Advocate Dalimpofu was not moving the judges, because a lot of them asked him hard questions throughout. And you could see that they're not for this guy in this particular instance. And these questions that they are asking Advocate Thembeka Ngcukaitobi, I think, are showing their reservations with disagreeing with some elements of what the Electoral Court has already agreed on. But let's see how the other questions then unfolded.
Mr. Ngcukaitobi, my question is slightly different. The respondent has raised some issues or preliminary points, one of which is a question of urgency, why you bypassed the SCA, and the other one is that the application is premature because the issue that's being raised should be determined by the National Assembly. Would you kindly deal with those issues?
Thank you. I mean, that's Justice Mhlantla. Let me start with the urgency and the SCA. There are three reasons that are pleaded in the founding affidavit for urgency and exceptionality. The first is the need for finality. The applicant has excluded Mr. Zuma from the list of qualified candidates. Whether he's entitled to contest cannot be established after he has contested. That would be absurd. Finality on the question, therefore, of eligibility must be reached before the 29th of May, not after the 29th of May. The question is, should he be a candidate or not? And the public is entitled to know the answer before it votes. It cannot vote first and find out later that he should not have been a candidate. Secondly, there is a need to safeguard the integrity of the election. If a leader of a contesting political party is allowed to contest while the Constitution disqualifies him, as the second respondent wants to do, because that's what Mr. Zuma wants to do, that will undoubtedly poison the election and produce a disputed outcome. The country will therefore be sleepwalking into an unfree and unfair election. And the consequences will be grave for our own commitment to the rule of law and commitment to our own Constitution. It will create the impression that we don't respect the rule of law and we are prepared to risk the legitimacy of our own electoral process. And then thirdly, the IEC says it has no practical relief beyond the 29th of May 2024 because the jurisdiction of the IEC is circumscribed to deciding qualification, working on a tight and a prescribed timetable. And therefore, if you don't decide the case before the 29th of May, for all intents and purposes, that will be the end of the road for the applicant because after the election, the IEC will cease having any legal interest in the dispute. And an appeal to the Supreme Court of Appeal now is simply not feasible because the matter will simply become moot and the second respondent will then have achieved what he seeks to achieve, which is to contest despite his disqualification. And then finally, on this point, you have dealt with a similar matter in principle, not on the facts, which was the case of Speaker of the National Assembly versus Public Protector. Incidentally, Justice Mhlantla, you wrote that judgment. And you will recall there that the same arguments, it's almost cut and paste, were made why you should not entertain the case. But in that case, you did not even have the strength of the facts you have here. You remember that the term of office of Advocate Ngcukaitobi was due to lapse in 2 years from the time the case was heard. It was not an election that is a few days away. And what did you do in that case? You entertained the direct appeal, despite the two objections of urgency and bypassing of the SCA. And why did you do so? We know your reasons are contained between paragraph 36 to 39. Firstly, you held that the appeal in that case was urgent, purely legal in nature, and concerned matters of public importance. This is precisely where we are. And secondly, you said that where there is a public interest and the fundamental principles of the Constitution are engaged, as well as fidelity to the rule of law, a matter should not be suspended in mid-air to take as long as it would take before it gets heard by this court, because that would not accord with the public interest and the finalization of important matters. You said that at paragraph 37. And then thirdly, you said it was necessary to save costs and time, particularly where the issue does not engage the development of the common law, but is a matter of crisp constitutional adjudication. And this is precisely where we are. And then fourthly, you said, well, we will look at the appeal when it bears prospects of success. No one can argue that this appeal doesn't bear any prospects of success. In fact, if you believe so, you must dismiss the case on the merits, not on direct appeal. And then finally, you said that you had heard the views of the full bench. In this case, you had the three views of the electoral court. They all diverge. But the fact is that you have the views of the specialist court. Our Constitution establishes this court as the specialist court in electoral matters. You had all of them. So we have our unique reasons that we have pleaded, and we rely squarely on public protector. And we say, when you look at the grounds on which you dispensed, when you were faced with the same arguments, you dispensed with urgency and dispensed with direct appeal. We fall full square on that authority.
Last question for now relates to the remission of sentence. I know that you said it's irrelevant, but it's one of the remission.
I want to comment on this because I don't think that's true. I don't think the first part of his answer is true, that the election gets poisoned if Zuma contests. Because if you remember, the provision 47(1) says if you have a pending issue, right, like if you're still going through the appeals process, it suspends, as he says, creates this fiction that you did not commit the crime, even though everyone knows that you may have.
That's the legal fiction he was speaking about.
Yes. But if I can contest as a candidate pending my appeal, how am I not poisoning the election? Right? Because I can, right? Let's say I did whatever and I'm appealing. Then I can contest, I can run, I can get into the National Assembly. If 6 months later the appeal is unsuccessful, then I have to leave the National Assembly. He's then saying it as if Zuma cannot do that too, under the argument of urgency. He's saying all of this must be resolved before the 29th.
Yes,
and
that's what he's saying.
And I don't think that that's true, that it's that urgent, because even if the court decides later that Zuma should not contest, right? I mean, should not be eligible, that can still apply in the same way that it can apply for somebody who ran while their appeal was still pending.
But Jamie, what about the electorate that he speaks about?
Yes, in both instances, the electorate would be choosing someone who may not make it through the legal process. But in both instances, they are given that choice. So I don't think it poisons the election. I think the danger to poisoning the election comes from removing a candidate who has already been running with the political machinery for 4 months now, 10 or 14 or 19 days before the election. I think that is more of a danger to poisoning the credibility of the election. Do you mean to tell me that the Constitutional Court comes back and says Zuma is out, that there will be people who are not dissatisfied with this, that there will be people who don't think that this election was free and fair, right? If MK party is polling at 8%, there may be 8% of the voters who view the election as being unfree and fair, and even more, right? This is why I think that this issue should have actually been taken, not on an urgent basis, because of some of the complications that it creates. And I think this is why the justice is asking this question. I think it is a relevant question, and I'm not particularly sold on the answer. But obviously the court will determine, but we're speaking at this particular point. I don't think that that distinction is a genuine distinction. I'm not persuaded by it. But let's see. Everything else, I think it's sound in law, but his interpretation that it poisons the election, for me, I'm not persuaded.
Remission, no, I didn't say remission is irrelevant. Remission is relevant because it's a ground on which we lost the case.
Okay.
Yes. What I said was irrelevant is the completion of sentence 5 years after the sentence has been completed.
Mr. Ngcukaitobi, I've been largely covered by my sister's questions, but I have one last one, also a preliminary point. The point is also made on behalf of the applicants that the Commission is not really seeking practical relief here. The applicants say that it really just concerns an individual's position, Mr. Zuma's position. In other words, they say this is a speculative exercise, and they invoke Ferreira versus Levine. What do you say about that submission?
It is a practical case. What has happened here is the IEC exercising statutory powers under Section 27 and Section 30 of the Electoral Act is obliged, it's not an option, it is obliged to determine eligibility of candidates. It received 22 objections in relation to Mr. Zuma. It upheld 2. Whether or not that decision was correct became the subject matter before the appeal court. The appeal court found against the IEC. The IEC believes that its original decision was correct. In other words, it correctly disqualified Mr. Zuma because he is disqualified by the Constitution. Now, it comes to the court to say that it wants you to reinstate its original disqualification decision. What will be the consequences of that? Those are set out at page 219, paragraph 70, 71, and 72. It will be able to remove Mr. Zuma as a contesting candidate. And this is a matter of immense constitutional importance because no one should contest for elections when the Constitution says they are disqualified.
Thank you. And lastly, just to confirm, I see in the papers that you're not asking for cost even if you're successful.
No, we are not. Yes, we've never asked for cost against MK and Mr. Zuma.
Yeah, thank you.
I agree with him. He's correct. There are practical implications. I think that when it comes to that particular question, the answer to the judges was correct. Advocate Thembeka Ngcukaitobi is correct. It's not theoretical. There are practical connotations to this in this particular instance. So I'm comfortable with that answer. You're learning law now.
I am. Yeah. This is Law 101.
Are you wanting to become a lawyer?
I can see it.
It can happen. Why not? They need more women in the legal fraternity. So the door is always open for you.
Jamie's giving me ideas. Let's watch.
Hey, man, it's not me. It's Thembeka Ngcukaitobi giving you ideas.
Mr. Ngcukaitobi, perhaps my question is for you to please just explain for me what your submissions are really on this issue of the doctrine of separation of powers. Because you say that if a president grants a remission or a pardon, that would amount to an encroachment of the power of the judiciary?
No.
What I need, okay,
That's what I'm saying.
I'm happy you're not saying that, because I would then, my next question would be whether you are saying that separation of powers is absolute or not.
No, we don't say that. That's one of the problems with the Electoral Court's judgment.
I thought you were agreeing with the Electoral Court's judgment on that score.
On remission, we don't say that the president has no power to grant remissions because that would violate the separation of powers. He does. The law allows him to do that. But the issue is whether or not, as a matter of law, a remission has the impact of reducing a sentence. We say that a remission does not have the impact of reducing a sentence for purposes of Section 47(1)(e). A remission has two consequences. One consequence is that it impacts the date on which you get released, which is what the Constitutional Assembly called execution of sentence. But when it comes to disqualification, remission is irrelevant, again, as contemplated by the Constitutional Assembly.
So your submission is contextualized?
Precisely. Thank you, Justice Chief.
I needed to clarify that.
Yes, no, it's excellent. Thank you for making that point. If I had created confusion, I apologize.
Okay, so this is just clarification. We don't need to...
On remission, okay.
Because on one part, which was the issue of does... because separation of powers is a principle in law and also in democracy that you want to keep, so absolute power corrupts, absolutely, right?
True.
So you want to separate the power and let everyone hold everyone to account. That's why you have the executive, the legislature, and the judiciary. And so part of the argumentation in the lower court was around whether or not the president has these powers, and if these powers are an encroachment of the powers of the judiciary, in that the president can undo the intentions of the judiciary in sentencing someone, right? But the real issue is interpretation of remission as it pertains to sentence, as it pertains to Section 47(1)(e), right? Does the remission amount to a reduction? And that's what we're going to hear the court speak on when they give a judgment, right? But this was just a clarification. Let's continue.
Mr. Ngcukaitobi, thank you very much for your submissions. I wanted to ask you a few points. The first that came up is the kind of question that we need to ask, because there's been some discussion, and you've referenced the travaux préparatoires, and it seems like almost you're making a claim that that because a particular interpretation is in the travaux préparatoires, that's something we should adopt. There was some discussion with my brother Matopa about the notion of the intention of the legislature, or the intention of the Constituent Assembly and drafters. My understanding is the approach in South Africa is not to adopt an original intent approach towards interpretation of constitutional provisions, and that the travaux préparatoires would only be relevant to the extent that it helps us understand the purpose of the provision as we're looking at the provision now. So I would like your submissions on that point about the interpretation and the way in which you're using those original documents.
Yes, we have referred to Mapanyane, paragraph 19, Mansing versus GCB, paragraph 27, and AMCO versus Anglo Gold, paragraph 57 to 61. So the first principle is that a travaux préparatoire is not a binding instrument on the court, but a travaux préparatoire is a useful source of understanding the purpose. But ultimately, you must decide what the purpose is. But what you need in order to decide what the purposes are the various sources. Source number one is the text. And source number two may be the history of the statute. And source number three may be the context of the statute in the rest of the Constitution itself. But the point I was making about the travaux préparatoire in this case is that when I read Mapanyane, Mansing, and AMCO, I found it striking that very few cases contain the direct question and issue. Like the very question and issue. They are usually an indirect source where you have to still skip 2 or 3 stages before you get to the ultimate meaning. And the travaux préparatoire here is on the direct point we're debating today. When does the disqualification come in?
Thank you, but the key point is that what we've got to do is construct the purpose, not try and work out what the drafters were thinking at the time in relation to this provision, because that's an important question as to whether or not the drafters actually contemplated a sentence, for example, that was handed down by this court in the way it was, or it can go both ways, actually, in some ways. So moving on, I wanted to ask you about the purpose. There's not so much that you say in your submissions. You talk about lawbreakers not being lawmakers, essentially, and it's left in that sense. Although, of course, some lawbreakers who fall under the 12-month provision can go to Parliament, right? So I want to understand from you a little bit more detail of how do you see the purpose of that provision, and particularly perhaps thinking a little bit about, there's some political theory around the notion of defense of democracy. To what extent can democracy protect itself from harms that come from democratic procedures themselves?
Yes. No, you are right, Justice Bilches, in pointing to the incompleteness of our theorization on the purpose part, which is why we've tried to supplement the purposive argument by showing that it's not stopping lawmakers from becoming lawbreakers for its own sake. There are two additional purposes that are linked to that. The one is to look at the severity of the lawbreaking. So it's cutting off at 12 months. And the reason it's cutting off at 12 months, it's cutting off at 12 months to indicate that there has to be a degree of seriousness. There has to be a degree of heft to the law breaking. So not every lawbreaker. So if I break the law because I'm driving at 120 in a 60 zone area, I'm not disqualified from going to Parliament. So 12 months is an indicator of the seriousness. There's a second one as well, which is when we say it's a protective purpose, it's protecting the public. Right? There is a public interest in ensuring that the people that are going to be deciding what the law is are themselves compliant with the law. And that's, but the threshold is it must be serious enough. And then it's the third one, which is the institutional integrity of Parliament itself. That is what disqualification provisions do. Is they protect the institution to which you are disqualified, but they also protect the public from you and from the institution itself. Now, we found this, I don't have to claim being the original, but we found this from the report on exclusion of offenders from Parliament of the 23rd of November 2018, and we've referred to that, and it's a useful source to explain why countries everywhere in the world have disqualification provisions that are linked to criminal behavior.
Thank you. So I wanted to proceed on the question of harmonization. Some of the international law, comparative law that we've been referred to, clearly recognizes that that disqualification provisions limit political rights of a kind. The Harvey case, the Paxos case, and various others that we have been referred to. We now need to interpret Section 47 and harmonize it in some way with other provisions in the Bill of Rights, with Section 19 and the right to appeal in criminal matters in Section 35. Why would a restrictive interpretation to disqualification as to only take place where an appeal is available, as is contended for by the respondents, not provide a more harmonious interpretation of these provisions with one another? In other words, why should we not interpret in favour of participation and so adopt a more restrictive interpretation of Section 47?
Yes, let me just start with the two premises of the question. The premise one is that there is a tension, and the reason the tension is mentioned is because of judgments like Harvey. South Africa is not there with any tension, because if the disqualification had been contained in an Act of Parliament, a law of general application, then an issue would arise between, there is a tension between a general right and an Act of Parliament. That does not arise in this case, because what has happened is that these are so serious that they have been included in the Constitution itself, which means then you go back to UDM, which tells you that there is no tension. The first principle is both sections must be given full effect. One does not take priority over the other. So this is why we say the matter is actually straightforward. Section 19 applies to people who are not disqualified, and it is not a question of restricting rights. I don't know the law under which the Harvey judgment was decided. I don't know the structure of their constitution. What I do know is South African law and the structure of the South African constitution. There's no tension, there's no need for harmonization. So my original...
I agree with you on that, because, not because, as you correctly say, many of those countries were interpreting a sub-constitutional law. So that's correct. But in cases where our law, for example, we're having to construct Section 47, and the argument is that there's some ambiguity as to which kind of sentence or conviction it applies to, shouldn't we then recognize that there would be a restriction on someone disqualified from standing the Section 19 rights, and therefore try and interpret Section 47 in as restrictive a way as possible?
No, it's an impossible proposition. Firstly, for what I say, which is Section 47 is a constitutional provision. It's not a subsidiary legislation provision. And if you are dealing with a constitutional provision, you must give effect to it in full. It's not limiting anything, because it cannot limit itself. You will be distorting the law if you took that approach. If you are to give effect to Section 47, you must give effect to its own purposes. It is a constitutional goal to restrict people that have broken the law in a serious way from becoming lawmakers. That is a constitutional goal. It is not a goal that somehow Parliament decided to insert, but it is a goal that was decided upon us by the people that drafted the Constitution. So that itself needs to be given effect. But it's also an absurd thing, because that Section 47(1)(e) also 47(1) also contains unrehabilitated insolvents. It also contains people that have been declared to be of unsound mind. So the moment you start saying my premise is Section 19, you always get into the risk that what you ultimately find, you find an unworkable Section 47, because what you do, you just debase it. You make it a free for all. And that is why we insist that if you are serious about the rule of law, you have to give Section 47 its full meaning.
Thank you, Mr. Ngcukaitobi.
Thank you, Justice Beatrice.
Lawbreakers can't be lawmakers.
That's true, unless, of course, they are waiting for an appeal or 5 years has passed, and there are some contradictions in that. But let's look at what the judge was concerned about more than the side chats. His concern is that you've got Section 19, which affords you political rights. You've got Section 35, which affords you the right to appeal. Then you've got Section 47(1)(e), which excludes certain people. And as you interpret constitutional provisions and laws, you're not supposed to do so in a way that is so restrictive that it constrains other rights.
Okay, so
That's
it has
the
to be
question.
flexible.
It has to allow for the maximum available expression of the other rights, right? And then you have to do a way up as per section 36 of the Constitution. But there's a bit of a tension, and in fact, maybe not a correct line of argument from Advocate Thembeka Ngcukaitobi in this instance. Thembeka Ngcukaitobi. This guy can't pronounce it. I can pronounce it. I can say Thembeka Ngcukaitobi. So anyway, the rights in the Bill of Rights actually have a higher status than other parts of the Constitution, and they require a higher threshold in terms of votes in the National Assembly to change them.
Okay.
So something that is within that Bill of Rights framework, which Section 19 and Section 35 are not necessarily in the same framework as stuff that happens later in the Constitution. So he's just saying it's all in the Constitution, so it's all good. But that's not 100% true, which is why the judge is asking him, why should we go for this restrictive interpretation as opposed to a more open interpretation, which does allow for people in instances such as this, where there is no appeal,
Yeah.
to actually be able
So
to.
Advocate Ngcukaitobi saying no room.
No room.
Yeah.
But the judge has a concern, which is why this question is being fielded. Now, whether or not he persuaded the judge, we'll see when the judgment comes out, but you learn a lot about the concerns. So I too am concerned about this, because Zuma did not get an appeal. You go to the court of first instance and last instance. You know, when I was in primary school, I read a book called God's Case, No Appeal. And this is basically...
And this reminds you of that.
Yeah, because
Yeah.
Ngcukaitobi's arguments are all God's case, no appeal. Concord's case, no appeal. Concord's... But he's ignoring that this right to appeal, it's important for a variety of reasons, especially ability of that particular litigant to be able to rectify or get some revisions or modifications to whatever happened in the first court, the court of first instance. When you're the first and last court, it becomes challenging. It becomes challenging to honor those particular rights. But let's see what happens next.
Thank you, Mr. Ngcukaitobi.
Thank you, Deputy Chief Justice.
Oh, sorry. It turns out that Justice Theron has questions for you.
Apologies.
Mr. Ngcukaitobi, can I refer you to paragraph 51 of the Electoral Court judgment, please?
Okay, which page of the record? Oh, 51 page of the record. All right, thank you. Sorry, Justice Theron, I need to find the judgment of the Electoral Court. Do you have the reference in the record? Of 400.
Volume 5.
400, yes.
Thank you, my sister.
Your juniors must earn their keep, Mr. Ngcukaitobi.
So they've now resorted to giving me their own computer. Yes, I am at page 400.
Yes. Do you take issue with the first sentence in paragraph 51? The drafters of the Constitution recognize the fact that a person convicted and sentenced has a right of appeal against their conviction and sentence upon leave being granted by the trial court or, if refused, on petition to the Superior Court.
No.
Do you take issue with the second sentence? If that fact was not important to them, they would not have inserted the proviso which seeks to preserve the status quo pending the appeal processes.
No, we don't. I mean, we've said so in our main submissions.
In other words, they refer to conviction and sentence. I would say, in other words, the disqualification does not take effect until the appeal process has taken place. Alternatively, a convicted person or sentenced person has elected not to appeal.
Yes, we've said so. We agree with that.
So, when courts interpret legislation, they must assume that the legislation must be taken to know the law. Is that right?
Yes.
Now, when we interpret Section 47, must we assume that the legislature, when it drafted that section, knew that in terms of our law then, at the time of drafting, every accused person has a right of appeal, subject to leave being granted?
Yes, but they would have known two things. One is that in a criminal trial under Section 35, there are rights because they have drafted them. They would also know a second thing, that there is also the right of direct access because they drafted it. All of this is in the same document.
They would also have known that direct access, which is a procedural provision regarding which forum you can take your matter to would not trump any other provision in the Constitution. That's what the drafters would have known.
Well,
and you made that submission a few minutes ago. You said where there is tension between provisions in the Constitution, both provisions must be given full effect. So the drafters of the Constitution must be taken to have known that.
No, Justice Saron, the drafters of the Constitution knew two things. They knew that there's Section 35 because they drafted Section 35. They knew there's Section 167, they drafted Section 167. They knew that it is a procedure, but they knew that if this court makes a final judgment, it becomes a final judgment. So you can't now just write out the other section.
Yes, but the drafters also knew that fundamental rights will not be taken away.
But Justice Saron, you've had that debate already with your colleagues twice. The debate about Section 35 and Section 12. This is not the case to have that relitigated again. That debate has been had. Whether or not a direct access case should result in the imposition of an imprisonment sentence was precisely the point at which you and Justice Ngcukaitobi disagreed. So this is not the case to relive that experience.
What we are doing, Mr. Ngcukaitobi, is to interpret Section 47 in the context of the law. Your earlier submission was that legislation must be interpreted having regard to the context.
No, I'm saying
what I am suggesting is that an important contextual factor in interpreting Section 47 is the fact that the legislature was aware of the right to appeal, which is a fundamental right. The legislature was aware that every convicted person would have a right to appeal. The legislature was aware that rights would not be taken away unless that was by specific design.
Yes, but
the legislature was aware that different provisions of the Constitution, where there's possible tension, would be read in order to give effect to both provisions. So if there's a tension between 167 and 35 or any other provision, the legislature was aware that both provisions would be given effect to, as you submitted a few minutes ago. And my concern is that we must apply the law equally and the same in every matter. All principles of interpretation as well should be the same. It shouldn't be said that, like I said a few minutes ago, you said where there's two conflicting or two provisions that have tension, both provisions must be given the full effect. So we can't do that in one case and not in another.
But Justice Saron, you've had this same debate because I've been in this court twice on the same case. This is the view you expressed in the previous two cases. The majority judgment found that it was not taking away any rights. So if you want to interpret Section 47(1)(e), you must take seriously the judgments of the Constitutional Court. This very point that you're putting to me, we've debated it twice. The fact of the matter is that the majority judgment found that merely finding Mr. Zuma in contempt and sending him to prison did not violate any rights in the Constitution of Mr. Zuma. This is an express finding of Justice Ngcukaitobi. She said so in the contempt, she said so in the rescission. So now this is the third time where the issue is being resurrected again. And now it's under the new vehicle of Section 47. So we referred to this in our heads of argument at paragraph 43, where we quote specifically what Justice Ngcukaitobi said, where she says the Constitution categorically allows the denial of the right of appeal by empowering this court to entertain matters by way of direct access. And that is at paragraph 79 of the judgment. So this debate has been held and it's been settled by majority judgment.
Yes, and that is why I don't understand your submission, Mr. Ngcukaitobi, when you say no rights have been taken away. Because the very passage that you refer to says that the Constitution allows the denial of a right. A few minutes ago, you said no rights has been taken away, and you said that was found, that's what the majority judgment found.
But it's not unlawful. This is the point, because they said it's lawful, it's permitted under the Constitution. So that's not unlawful. So there's nothing wrong in that finding. It's a binding finding of the court. Now, you cannot say, I want to interpret Section 47(1)(e). In order to do that, I must undermine the majority judgment. That itself is a violation of the rule of law.
When this court interprets Section 47, must it have regard to the context that when Section 47 was written, the context was that every accused person had a right of appeal.
Justice Saron, we've debated that 10 minutes ago, and I have said twice that it also knew that there is a direct access provision, and it also knew that when the direct access provision is engaged, the outcome is that you have no right of appeal, because this court is a final court of appeal.
Now, apart from the Zuma contempt judgment, where that principle emerged from, is there any other authority for that proposition or principle?
No, the Zuma contempt judgment is the binding authority. That's why we refer to it.
Yes, my question is there any other authority?
No, I submit, Justice Saron, there is no need for us to find other authority, because you have a binding authority which is recent.
Let me finish my question, please.
All right, I apologize.
Apart from the Zuma contempt judgment, where that principle emerges from, is there any other authority in support of that?
No, we don't rely on any other authority. We rely on the Zuma contempt judgment. We say it is binding, it's recent, you should follow it.
My question was not what you are relying upon, Mr. Ngcukaitobi. My question was, apart from that judgment, is there any other authority?
Nothing that we have found, but we say, and this is my submission, you are bound by the judgment, you can't undermine it because you're undermining your own judgments.
Now, if we look at section 47, it does not say that in some instances the proviso will not apply. And I understand that to be what the applicant is arguing, that in this case, in the facts of this case, the proviso doesn't come into operation.
Yes, what we say about the proviso, thank you for that question, and hopefully we can go back to the proviso. What we say about the proviso are three things. Firstly, it's a deeming proviso, and the deeming proviso from Chotabai is that it deems things to be what they are not. Secondly, we say a proviso cannot undermine a controlling section. In order to know the full meaning of the section, you've got to look at the controlling section. And thirdly, we say its purpose is to allow an appeal to take place. But once this judgment was granted by this court, that purpose was fulfilled because this court acted as a court of first and last instance.
If we look again at the electoral court judgment, paragraph 50.
Same page. Yes, I'm there.
The third sentence.
Third sentence of what?
Paragraph 50.
Yes, I've got that.
Justice Zondi says, this construction, which the Commission seeks, requires the court to read in words into section 47(1)(e), the effect of which will be to exclude the operation of the proviso in section 47(1)(e) if a person concerned was sentenced by the highest court in the land. What do you say about that?
No, it's wrong, because the effect of what we're contending for is simply this. If a judgment has been given by this court acting under section 167 as a court of first and final instance, the object of the section, which is finality, has been achieved.
If the legislature envisaged that there would be a class of persons against which the proviso would not apply, shouldn't they have said so?
There is no class of persons from which the proviso doesn't apply. It applies to everyone, including those persons that have been sentenced by the Constitutional Court. It's the other interpretation that creates the arbitrary distinction.
What does the word until mean in the proviso?
Well, it's obvious what it means. It means it's to open up the possibility that the appeal must be finalized, but that possibility has been exhausted once you have made the decision.
Well, it hasn't been exhausted. It wasn't granted. There was no possibility of appeal.
Yes, but
so the proviso never kicks in.
That's the consequence of the fact that you exercise original power and you exercise direct access power. So what that means is that finality, the section is there to preserve finality, but finality is achieved as soon as this court makes a decision.
On the assumption that section 47, that the drafters of section 47 had in mind that every convicted person in sentence has a right of appeal, subject to leave being granted. Let's leave out the possibility of being sentenced by this court with no possibility of appeal. What possible interpretation would there be to section 47?
No, but even with that construct, sorry, Justice.
I think, Mr. Ngcukaitobi, I've been watching for a while, keeping quiet. It might be helpful just to tone down a little bit. You come across as being very irritable, irritated and impatient with Justice Theron, and it's not seemly. Just relax and let her finish her questions. You're not going to get questions you like all the time. Just answer the question,
I apologize, Deputy Chief Justice. Sorry, Justice Theron, I should be apologizing to you.
Mr. Ngcukaitobi, I know you mean no offense,
yes,
so I take now.
Yeah, no.
We have walked a little way
yes,
together.
No, I know. Yes.
Okay. On the assumption that the drafters of section 47 had in mind that every convicted and sentenced person would have been afforded a right of appeal, where a person has not been afforded a right of appeal, what options would be open to this court as to how to interpret section 47(1)?
I was saying, even on that construct, even on the construct you have given, you still have the possibility that a criminal trial takes place in the magistrate's court, takes place in the high court. This court decides that the sentence is too lenient and it imposes an original sentence. You still come back to that point. If they are correct at the electoral court level, that means you strike out the entire section 47(1)(e).
Sorry, I only heard the last part where you said, if that, and then I missed some words, you said, I mean, to strike out the last part of 47(1)(e).
No, I'm saying that even on that construct, in other words, the construct in which we have a full trial before the magistrate's court, and a full appeal before the high court, and a full appeal before the Supreme Court of Appeal, you still have the possibility that this court has the power to impose its own sentence if it believes that the sentence originally imposed is too lenient. So you come back to where we started, which is there is no way in which you can interpret that section as excluding sentences imposed by the Constitutional Court.
But that would be an appeal, that would be a sentence altered on appeal. It would not be a sentence as an original sentence. While we're on that,
Incorrect sentence.
The magistrate's court gets its penal jurisdiction from the Magistrates' Court Act.
the High Court gets its penal jurisdiction from the Superior Courts Act. As I understand, the Supreme Court of Appeal does not have penal jurisdiction. Where does the Constitutional Court get penal jurisdiction from to impose a sentence as a court of first instance?
Well, you've exercised that power because you were exercising original constitutional jurisdiction, and you imposed it in the context of Mr. Zuma, the same as exercising the power as an appeal court. The Supreme Court of Appeal has done so several times, and we can refer the court to its many judgments where it increases the sentence as opposed to examining the sentence imposed by the lower court as a court of appeal. So the law is clear that even the court of appeal have penal powers.
Yes. I'm not dealing with the powers of a court of appeal or the powers of a court hearing an appeal, to the power to decrease or to increase a sentence. Talking about a power to impose an original sentence and the penal jurisdiction that grants the court that power. And if I understood your answer was that this court would derive that source of power from its constitutional jurisdiction.
Yes, I'm saying the Constitutional Court derives original sentencing power from the Constitution itself. It has exercised it in the Zuma case.
And does this arise from the direct access provisions?
Yes.
And so you say from the direct access provisions, this court derives original penal jurisdiction?
Yes, but it also derives it from Section 172, just an equitable remedy, where it has found that the Constitution has been violated. And in the case of Mr. Zuma, it was a direct access provision, and it had found that its own judgment was violated, its own authority, its own standing was threatened, and it exercised original constitutional jurisdiction. In fact, if you look at if you look at that page 71 I was referring to earlier, it's page 71, not paragraph 71. If you look at the order itself, it's at page 70, paragraph 71. It was a declaration, paragraph 3. It is declared that Mr. Zuma is guilty of the crime of contempt. And then Mr. Zuma is sentenced to undergo 15 months imprisonment. So the court did exercise original sentencing power.
If I can take you to the Sibiya case.
Sibiya?
Yes.
I'll have to find it, I'm afraid. Anyway, let's hear what the substance of the issue is.
The respondents rely on the following passage from that case. I think it's at paragraph 40 to 43. It says, the president does not determine the sentence, but merely imposes it. And then a few lines down, it says, the president substitutes the sentence recommended by the judge in a situation where the person whose sentence is
substituted. Where are you reading? I'm sorry to stop you, but I don't follow where you are reading from. Which paragraph?
It's a paragraph that's quoted in the respondent's heads at page 120.
All right. Which paragraph of Sibiya? I've got Sibiya in front of me.
Can I refer?
It's 41.
Yeah.
Yes. It's paragraph 41.
Yes. The president substitutes the sentence recommended by the judge in a situation where the person whose sentence is substituted has already been tried, convicted, and sentenced, a person in respect of whom the judicial process is over. And I suppose the applicant would support that position regarding remission.
Sorry, Justice Saron, you'll have to put that again because I've just looked at the facts of that case. It was a case about substitution of death sentences. So, which has nothing to do with the power of remission.
The respondents rely on it in respect of the doctrine of separation of powers.
So we don't take issue with the doctrine of separation of powers. What we say is that if you apply the remission, because Mr. Zuma did not get a commutal sentence, you'll see in that judgment, it's paragraph 18, it's a substitution of a sentence of death. And historically, it has always been acknowledged that the president, as head of the executive, is entitled to commute a death sentence to a sentence of life imprisonment. That has nothing to do with a remission, which is what the case is about. It's a case about a remission. The question for a remission is a narrower question, which is whether or not the effect of a remission is to amend the original sentence. And the problem here, Justice Saron, that's probably a good thing you've raised this point. The problem here is that you have the electoral court finding that the sentence was 3 months. And it makes that finding without any textual support, either in the judgment of this court or even in the decision on remission. It imposes its own sentence retrospectively. And then, that's number one, the clear distinction. And then look at what is the law on remission. The law on remission is, the remission simply impacts the duration of the sentence to be executed. It does not impact the original sentence. What is the position of section 47(1)(e)? 47(1)(e) is clear. It is not about the original sentence. It is about the original sentence. It is not about the execution of the sentence. So I'm afraid Sibiya is irrelevant.
The respondents say that, or they criticize the applicant. They say section 47(1)(e) is concerned with the length of sentence imposed. Just a minute. criticizes the IEC, it says that the IEC does not provide any authority for the submission, that Section 47 is concerned with the length of sentence imposed and not sentence served.
Well, we have dealt with this at length. Firstly, we have said it's the text, because the text says sentenced. It does not say sentence served. Number two, we've said it's the object behind the text. Who sentences? It is only a judge that can sentence. Whatever the president does about a remission, he cannot sentence. He can always impact the length of the sentence to be served. But what he can never do, he can never sentence. Section 47(1)(e) is about who sentences, and only the court sentences. And then we have drawn the court's attention to what the drafters of the Constitution thought about remissions.
I may be wrong, but it seems to me that both the applicant and the respondents rely on Smith and Boshego.
We don't rely on Smith and Boshego. We just say that they've been incorrectly invoked.
Do you say they're not applicable in this matter?
Yes, they are inapplicable because those judgments were about parole. This is not a case about parole. In fact, Mr. Zuma disavowed parole. We have no problem that a remission has the natural effect of reducing the sentence that you serve. I mean, that is clear. You get out of jail. The issue is, we say that parole does not affect the original sentence. Section 47(1)(e) is about the original sentence.
Thank you, Mr. Ngcukaitobi.
Thank you, Justice Saron.
Still not sold?
Well, there's something that I want to point. Did you see this exchange? It was very tasty for him.
I did.
And he was very dismissive to the point that Mandisa Maya had to step in and say, listen, guy, you're not always going to get questions. No, I think it was Maya, saying you are being disrespectful. You are being disrespectful. You're cutting the judge. You're asking me earlier about Advocate Thembeka seems to cut off judges. Did you see Thembeka Ngcukaitobi doing that multiple times with Theron?
I think at a certain point I even felt like he's irritable. You know, he just feels
but
like...
he doesn't have stature to be irritable towards a judge.
Right.
Do you understand? It's like you being irritable to the CEO. In what kind? Do you understand?
Yeah.
So there was a little bit, and he was actually not responding to some of her questions because he kept saying, we dealt with this. We dealt with this before. This is round 3. You want to resuscitate this. And in so doing, he did not respond to her genuine concerns that she was raising about the intention or the purpose of the drafters in creating that particular section. Because she says, when these drafters drafted this, did they really envision a situation where someone would then be in a situation where they are going to a court where they have no appeal?
Right.
And all he says is, well, they drafted the other parts which say there's a first instance and the court can be a court of first instance and has these powers. But he's not actually answering a question to say, is it possible that they didn't consider a situation such as this, where the facts are so peculiar that they have created this anomaly? And all he says to her in those stages is, "Aiwena, you're trying to do it. You're trying to argue this again."
What about? What's your reaction to his responses when she was, giving examples? That she spoke about the severe case, and I think she made 2 other examples after that, and he kept saying it's irrelevant.
Yes. So you remember, like even at the first electoral court case, do you remember when the other judge said, no, it's irrelevant. It doesn't matter, when the judge had said, just because you say it's irrelevant as an advocate doesn't mean that the judge thinks it's irrelevant.
Right.
You sometimes have to actually apply your mind and answer fully. You remember, they asked in the first electoral court case that, hey, why didn't you guys raise this objection at the beginning?
Yes.
And why didn't you do this? And why didn't you do this?
Yes.
And that advocate, I can't remember her name now, said, it doesn't matter. It's irrelevant. It's immaterial. All we want you to do is look over here. And then the court came back and said, hey, actually, it was relevant. And we looked at your answer, and your answer was unsatisfactory. So I think that he has lost Justice Theron. I don't think he persuaded her. I think that she's going to dissent if the majority agrees with him. But I also don't think he has the majority necessarily. And they may very well rule in his favor and in the IEC's favor. But from these questions, it makes me think that Umkhonto Wesizwe has a chance. because this is particularly about that issue, about what was the purpose of 47(1)(e) as it pertains to an instance where someone has no appeal.
Right.
He is assuming because this court is the one that imprisoned Zuma and put the sentence, that they are not going to carefully consider this issue. But from judge to judge to judge, we've heard questions being asked about this issue.
Yeah, they sound to be concerned about the same thing.
Yes, and so remember, one thing that you must never do is forget that you're listening to professional, expert communicators. So every time Advocate Ngcukaitobi speaks, it's very powerful. But you have to be following the argument and trying to break it down. So he's a brilliant advocate. He's very brilliant. But I'm not sure that all of his answers actually advanced the case. And I'm not sure actually that the judges who were asking him these questions were persuaded. Do you understand?
Yeah.
So it's not about me, it's just about us trying to look and see. But I do have a deep concern just about everything that happened. And I think Theron has it too when she says, this court ought not to have assumed that it has penal powers. Ngcukaitobi says, no, it's fine, you have the power. But there's something about that. He's excited that they do that.
Yeah.
She's concerned that they do that. Because she says, look, I'm comfortable with us raising it or decreasing it. I think we have the power, and so does the Supreme Court. But I'm uncomfortable with us doing the whole thing from start to finish. She's saying, I'm uncomfortable with God's case, no appeal. And she shows Magistrate Court gets its penal powers over here. High Court gets its penal powers over here. And she's saying, we don't have that authority. Can you give me authority? He says, I can't give it to you, but you have it. And then she also asked him, outside of this judgment, what other judgment supports your position outside of the last one?
Yeah.
He's like, no, it doesn't matter. This is the latest. This is the latest. This is the greatest. And
because you repeated that question.
yes,
a
and he
couple of
didn't.
times.
He didn't want to answer it. He didn't want to answer it. Do you see? Because he knows that there is no other judgment to back this up.
Right.
This is a unique set of circumstances that has
Right.
created this anomaly, and it is an anomaly, and I still maintain that it's an anomaly. The very fact that we have had Zuma 1, Zuma 2, and I think this is Zuma 3, if not 4, around this same issue, shows that there's an issue here with what was done, right? And we're still trying to reconcile it.
Looking at these arguments, Jamie, do you still think that they should not have taken this case on an urgent basis?
Yes, I wouldn't have taken this case on an urgent basis. I don't think that the arguments that Ngcukaitobi made about that persuaded me. But remember, I'm commenting. The judges are going to make the decision, right? And we'll see what they say. But these concerns that they've raised
Are real concerns.
are real concerns, and they indicate that the IEC may not have it. They may have it, but they may not have it. They may not have it.
Should the electorate be worried?
Should who be worried?
The electorate.
Look, this is a very volatile situation. In 2021, we all pretended as if this was a legal exercise, purely. And those who were saying rule of law, rule of law, rule of law, were very, very negligent in that the real world exists outside the constitutional court and where is it, in Hillbrook, right? There's a real world beyond that. And we saw that real world come crashing down on South Africa. So these things are happening in a very delicate moment. And Ngcukaitobi on one side is arguing that no, there'll be a theft of an election, the election will be compromised. But I think there's also a view that to prevent this man on a rigid interpretation of this rule, after he has won 3 court cases, one at the Electoral Court, number 1, one at the Durban High Court, number 2, number 3 at the Electoral Court again, and for then the IEC to go forum shopping to the Constitutional Court because they view it as being harsh against Zuma and favorable. There are going to be people who are not going to necessarily be comfortable with Zuma being removed from the ballot 19 days before the election, or 10 days or whenever we get the judgment.
Yeah, whenever we get the judgment.
This is a precarious time. This is serious stuff. And this is not trivial. This is real life.
Shouldn't be taken lightly. Yeah.
This is real life. And I still have concerns, but we're out of time for this part. I'm going to try to record another part, but you won't be here to look at some of the questions that were asked to Advocate Delimpofu. But I think we can get some understanding of the legal issues that were at stake, what was argued, and some of the concerns that the judges had from this segment.
I must say, it got really heated.
Yeah.
Even before, you
Yeah.
know, the exchange between Advocate Ngcukaitobi and Justice Theron,
Yeah.
even with just the other justices,
Yeah.
you could tell that this is really tough.
Yeah, it is tough. What do you guys think? Did you watch the case? Where do you stand? Who has been persuasive to you? Let's have a conversation.